Well, HDL had a trustee that was responsible for collecting all of its assets and distributing those to creditors. Among the assets that the trustee identified was money that had been transferred out to its independent sales consultant, Blue Wave. That money in turn was distributed to its owners, and then its owners had made charitable contributions. The bankruptcy code allows the trustee to go after not only the original recipient of the transfer out of the debtor, in this case HDL, but to subsequent transferees to the extent they can identify it as the debtor's money. In this case, the trustee chose to pursue 3 steps out from the debtor to go after churches that had been given money by the owner of the independent sales force. Unfortunately, those churches had received the money with the expectation that they spend it on charitable endeavors, such as feeding hungry, giving Christmas toys to kids that are needy, and the churches no longer had that money. Unfortunately, the court upheld the trustee's right to do that, and so that these churches are going to have to come out of pocket for money that they no longer have. Outside of evidence of fraud, meaning that the third party out was involved in the fraud, I've never seen it. Certainly if you have a second or third transferee who was involved in the original fraud, that's understandable. But in a case where you've got a completely innocent party that everybody agrees was innocent, to go after them, we really couldn't find any authority one way or the other in American jurisprudence. I certainly think Congress needs to look at imposing protections on remote parties such as these churches, particularly when they have no involvement in the fraud.